start taking into consideration the peculiar facts and circumstances of the case, since the suit is still in the preliminary stage, we dispose of the appeal is directing the trial court to frame the issue, relating to the maintainability of the suit and applicability of enactments, as mentioned supra, and decide the same in accordance with law as a preliminary issue as expeditiously as possible, preferably within a period of 6 months from the date of communication of this judgment. It is in appeal from such order of the trial court that the impugned judgment with particulars as noticed above, came to be passed. The High Court, while upholding the jurisdictional issue in favor of the respondent tenant, dismissed all the 4 suits of the plaintiff for the same not to be maintainable. Thus, the issue as already observed is as to whether the order passed by the High Court holding the respondent tenant to be governed by the Tenancy Act, is legally sustainable or not. During the course of the hearing on 15th February 2024, petitioner applicant landlord had offered time to the tenants to vacate the premises. Certain suggestions for amicably resolving the dispute for all times to come were exchanged, and as such the matters were adjourned. We are now informed that the petitioner landlord's offer of giving time to the tenant to hand over the vacant position of the premises stands rejected. Thus, the landlord insisted on the disposal of the applications, asking the tenant to pay the rent at the market rate for the lease to have been determined at the institution of the plaint. Since the special leave petitions are pending adjudication, we make it clear that directions made in the above stated interlocutory applications herein are subject to the final outcome of the former. Keeping in view the location of the demised premises, the rent as agreed, the alleged non-payment of rent, the default in payment of interest, as alleged, and other such like factors, we are inclined to accept the calculation of dues as made by the petitioner applicant, submitted to this court during hearing, as reproduced herein above. The rent so fixed should be just, proper and inadequate, keeping in mind the location, type of construction, accessibility to the main road, parking space facilities available therein, etc. Care ought to be taken that it does not end up being a bonanza for the landlord. The parties shall be at liberty to get the rental fixed by the official valuer.